Good morning, afternoon, evening, everyone, and welcome to our webinar. I'm Deborah Healy, Co-Director of the Herbert Smith Freehills International Business and Economic Law Centre and a Professor at UNSW Law and Justice, and I'm delighted to welcome you to the sixth and final webinar of CBIL's 2021 Global Network Conference. And I begin today by acknowledging the traditional custodians of the lands on which we meet, the Bedigal and Gadigal people, for where UNSW stands, and pay my respects to the elders past, present and emerging. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who may be present here today. This panel consists of 4 presentations and a Q&A. Each presentation will be approximately 12 minutes long, and I'll introduce the speakers now before they speak. So our first presentation is from Professor Carsten Nauert and Christina Hellwig. Professor Nauert is a Professor of Public International Law, European Law and International Economic Law, and Director of the Research Institute for Economic and Labour Law, as well as the current Head of Department of Law at the School of Socio-Economics in the Faculty of Business, Economics and Social Sciences at Hamburg University. He is also an affiliated professor at the Faculty of Law at Hamburg University and serves as Deputy Director of the Master's Program, European and European Legal Studies at the Institute for European Integration of the Europa College in Hamburg. He was, among other things, a visiting professor and Global Challenge visiting scholar in 2015 at Seoul National University and has been a visiting professor at Kobe University Graduate School of Law. In the 2 speakers, Professor Nauert and Christina Hellwig, will speak to the same set of slides. Christina Hellwig is a lecturer and researcher in the Department of Law at the School of Socio-Economics, the Faculty of Business, Economics and Social Sciences and the Faculty of Law at Hamburg University. Her primary research areas are public international law and human rights law. She received her legal education at the University of Hamburg and Saarbrücken in the year 2016. She participated in the Mirai program organised by the Ministry of Foreign Affairs of Japan, and prior to her position as a researcher, she gained practical experience in investment law and arbitration by working at the law firm Luther on their arbitration team. The topic of their presentation today is Incorporating Investors' Responsibilities in International Investment Agreements, What Role for China? Thank you, Professor Nauert and Christina Hellwig.
Yeah, thank you very much, Deborah, for the very kind and quite comprehensive introduction. Christina and myself are very happy and feel very honored to be invited to take part in this exciting academic event and for giving us the possibility to share with you all some thoughts, no more than that, on the issue of investors' obligations in investment agreements and the current and in particular potential future role of China in that regard. We have subdivided our presentations into 2 parts, as indicated by the, as suggested by the title of our presentation. I will briefly introduce to you the current manifestations of the different types of provisions dealing with investors' obligations in investment treaty practice that have more recently emerged, and then Christina will take over and deal with the role of China in that regard. And I better start now also, because otherwise by the time for my part of the presentation will be almost up. Next slide, please. The issue of investors' obligations is rather of a more recent character, at least as far as investment treaty making practice is concerned. Most of you, or many of you, will know that when modern investment treaties emerged in the end of the 1950s, they were primarily dealing with the protection of foreign investors and their investments, and in that regard quite consequently were stipulating only reciprocal obligations for the contracting state parties, but were silent on direct and indirect obligations imposed on covered investors. That was left largely to the host state law. Next slide, please. That has changed more recently in the last 10 to 15 years as a result of the ongoing processes of what has been referred to as a reconceptualization or reformation of international investment agreements as a whole to make them more balanced. One of the regulatory approaches more recently taking recourse in that regard is actually the introduction of investors' obligations in that connection. And we see that already in current investment treaty making practice in the last roughly 15 years. Next slide, please. And in order to try to systemize the wealth of different provisions we find in that regard, we suggest that you can basically distinguish between three different types of provisions. The first one we have termed direct obligations of conduct. That's from a legal regulatory perspective probably the most common, most natural approach. At first sight, however, still quite rare in treaty making practice in the investment realm. That are legal obligations of investors explicitly stipulated and directed to them in investment agreements. We find among the rare examples we find in current treaty practice is already an older one from 2007, Common Market of Eastern and Southern Africa Investment Agreement. Article 16 obliges the parties to accord priority to workers when they in their hiring practices available in the respective member state. Next slide, please. And more recently, we see, for example, the bilateral investment treaty concluded between Morocco and Nigeria that hasn't entered yet into force, signed in December 2016, which provides a number. I've only given you here a selective overview of the obligations for foreign investors, among them also the obligation to uphold human rights in the host state. Or we find in treaty making practice the obligations for investors enshrined as treaty obligations to comply with the laws of the host state, as for example manifested in the bid between Brazil and India. Next slide. A second approach is what we term the more indirect regulatory undertaking, indirect obligations of conduct. In that regard, the treaty parties do not decide to directly stipulate obligations for foreign investors, but rather require themselves, the contracting parties, to consider and adopt measures aimed at regulating their behavior. That's an approach we find also in treaty making practice and environmental law, some human rights agreements and others. And in the realm of investment law, I've given you here two examples. The first one, Article 72 of the economic partnership agreements between the Caribbean states and the European Union. The parties shall cooperate, take measures to ensure that investors act in accordance with core labor standards. Next slide. And a more overarching approach that does not exclusively apply to foreign investors, but also to foreign investors, can be found, for example, in the recently concluded bid between Japan and Georgia. Each contracting party shall ensure that measures and efforts are undertaken to prevent and combat corruption in the respective countries, and that most certainly also applies to the conduct of foreign investors. Next slide. And the final and third approach are provisions of a more softer character that merely signal a commitment by the contracting state parties to promote corporate social responsibility. We find such provisions or such regulations in the preambles of the agreements, and as you see from the respective example, and or also in the operational part of the international investment agreement. We have given here you one more recent example from the investment chapter of the Indonesia-Korea Comprehensive Economic Partnership Agreement. Okay, that concludes my part of the presentation, and with that I hand over to Christina for the second part.
Thank you. So I will continue now with the second part, the role of China. Notably, despite the high number of treaties concluded by China, the issue of investors' obligation is of now not feature or prominent role in most of China's investment agreements. Rather, it seems that China has until now relied on a more traditional approach. There are a few notable exceptions. Next slide, please. In which, however, it can very well be assumed that China was not the driving force for the inclusion of such provisions, but rather accepted the cause by other respective treaty parties. You see some examples here, which I will not comment at the moment. Against this background, the question arises whether the current status quo approach by China is in need of at least modification. It is submitted here that even though the practice before mentioned is rather innovative, the better arguments speak in favor of China adopting the more innovative and balancing approach in their treaty practice. We would like to highlight a few main aspects in an attempt to at least briefly substantiate our perception. Next slide, please. The first aspect is connected with the work of the open-ended intergovernmental working group on transnational corporations and other business enterprises with respect to human rights. First, we would like to recall that from the very beginning, China has been a supporter of the open-ended intergovernmental working group, and that China was one of the 20 countries that voted in favor of its creation. And since then has been an active participant in the subsequent discussions and negotiations. And a central, quite innovative, yet not uncontroversial provision within the most recent third revised draft of this working group will establish the primacy of human rights over state obligations arising from international economic treaties and also arbitration treaties. The legally binding implementation of such a standard would clarify some current issues in the context of ongoing arbitration proceedings. However, it will also lead to a fundamental change in investment protection as a regime. Despite obvious difficulties with making reliable predictions as to the chances of the draft being adopted in the foreseeable future, it seems not too far-fetched to suggest that a country like China, that has from the very beginning actively supported the work of this area, the work in this area, that the incorporation of provisions in the investment treaties to ensure the compatibility with this potential future treaty would be good. Second important consideration is China's increasing influential role as a rulemaker in international economic governance, providing politically feasible and acceptable and thus sustainable answers to questions surrounding the concept of corporate responsibility as a task requires active participations of the most influential rulemakers. And this finding is undoubtedly also true for China. And a policy shift on the side of China would be beneficial from the perspective of fostering the incorporation of broader public interest concern into investment agreements. And additionally, it would also provide the possibility that as China is currently active in a lot of countries as an investor, or rather Chinese investors are active quite actively, it would also help to provide and mitigate some of the social political concerns the investors are facing. Therefore, a more active and progressive policy approach towards the concept of investors' responsibilities and their implementation in practice would also be in China's own interest. In conclusion, we argue that adopting such an approach has the potential to further enhance the status and reputation of Chinese companies as responsible foreign investors, and consequently to potentially also reduce the political social concerns currently existing or potentially emerging in the future in a number of recipient countries. Thank you very much.
Thank you very much to the speakers, and thank you very much for keeping to our time. We've both done that very well and we appreciate that. As we said at the outset, we will be having questions at the end for all speakers. So I turn to our next presenter, Dr. Mark McLaughlin from Singapore Management University. Dr. McLaughlin is a visiting assistant professor there and at CIDRA. His research focuses on dispute resolution, the Belt and Road Initiative and international economic law. He has published articles and book chapters on the Chinese approach to investor-state arbitration, the interaction between state-owned enterprises and international investment law, and the legal infrastructure of investor-state mediation. He holds an LLB from the University of Glasgow and a PhD from the China University of Political Science and Law, where he was a lecturer in international investment law. Mark was awarded a Chinese government scholarship from 2016 to 2019, and his topic today is managing state capitalism in Asia, national security, competitive neutrality, and investment obligations. Thank you, Mark.
Well, thank you very, very much for that kind introduction. And as has become the customary greeting with these conferences, good morning, good afternoon, and good evening to everyone joining us from all around the world. So for the next 10 to 12 minutes or so, I'm going to take you through some of my findings about the role of investment obligations in managing state capitalism in Asia, now particularly when Asian investors are operating overseas. Now, the rise of outbound state capitalism, that's the state-backed foreign investor, is a relatively well-observed phenomenon in global economic governance. And Chinese state-owned enterprises in particular have been paid a significant degree of attention, but state-backed investors from Qatar, Saudi Arabia, Kuwait and India have also had cause to make significant investments overseas. And that's the background or the broader context of where our examination starts today. Can I have the next slide, please? Now, when Asian investors or Chinese investors in particular are operating overseas, there are particular concerns raised by host states about the nature of that investment. Now, I've split them generally into three categories. There is some overlap between these categories. For example, issues of corporate governance necessarily impact upon issues of competition and security. But nevertheless, the three main concerns raised by host states are national security, competitive neutrality, and corporate governance. Now, more specifically with national security, the issues are the potential for military or industrial espionage, the monopolization of strategic resources, and the risks to critical infrastructure. Now, often these are inherent to the particular areas in which Chinese investors tend to invest, and others is about the nature of the controlling entity, the nature of the government that necessarily controls that investment. Now, with competitive neutrality, the issues that are associated with it are things like if state-owned enterprises are subsidized, if they are subject to regulatory favoritism, if there is preferential public procurement, if there are aspects of the state-owned enterprise whereby a government has kind of golden shares or captive equity, or the extent to which that state-owned enterprise may have sovereign immunity when it is operating overseas. Thirdly, issues of corporate governance relate to, in particular, the non-commercial policy objectives or the political nature of particular investments. Whether state-owned enterprises have particularly low levels of transparency, or whether they operate under lower standards of responsible business conduct. Now, these are the areas that are raised by host states in relation to Chinese investment operating overseas. Next slide, please. Now, the most powerful tool that host states have in order to try and regulate or manage this kind of state capitalism when it's operating overseas are the investment screening mechanisms used by host states. In other words, when host states can control who's coming into their country and impose conditions upon that particular investment. Now, I've had a close look at four in particular here that are quite kind of high value destinations for investors coming from Asia. The first is the United States, which has the Committee for Foreign Investment in the United States. Then you have Canada, which has the Investment Canada Act. the EU, which did have merger control and now has its own investment screening mechanism, and fourthly, Australia's Foreign Investment Review Board. Now, in many ways, there are very different legal tests applied by these screening mechanisms, but in other ways, there are characteristics that are common to all of them. One of them is that there's a lower review threshold for acquisitions by state-owned enterprises. Secondly, that there are transparency, character, and commercial purpose tests that can be applied. And thirdly, that these investment screening mechanisms tend to be highly discretionary and have some kind of political involvement. So normally there is a kind of administrative body that will apply particular legal tests, but the final decision maker is quite often a minister who is, at the end of the day, a political actor. The judge is it's not, for example, a solely legal process. There is some degree of political element. Next slide, please. So as we know, when investors are being treated by host states, they do not operate in a legal vacuum, that there are particular obligations that apply to host states that they cannot treat particular investors in a particular way. And one of the most prominent is non-discrimination, so that you cannot discriminate between domestic and foreign investors that operate in like circumstances. Now, there are some elements of non-discrimination that are particularly relevant in this regard. The first is that the principle of non-discrimination in most bilateral investment treaties only applies at a post-establishment stage. So pre-establishment, in terms of when can the investor actually enter a country, generally is not regulated by international investment treaties. And even when it is, when pre-establishment national treatment is established by investment treaties, the sectoral carve-outs, the carve-outs for those pre-establishment national treatment overlap with areas of national security, for example, in the telecommunications sector or for infrastructure and particular sectors like that. So even where there is pre-establishment national treatment, investment screening mechanisms will often not be covered under many bilateral investment treaties. Secondly, when the prohibition of discrimination refers to domestic and national investors when they are investing in like circumstances. Now, the key test for establishing a particular investor is what is the content of likeness? What does in like circumstances mean? And so the prominent question in relation to state-owned enterprises is, does state ownership provide host states a justification for differential treatment? Now, bilateral investment treaties on the whole do not provide an answer to this question, apart from the India model bilateral investment treaty, which does provide that ownership is a basis of discrimination. Generally, most bilateral investment treaties do not provide that clarification. So there is a case, UPS versus Canada. Canada Post, that had particular obligations from the host state to deliver to all areas of the country, as exists in many countries, and UPS attempted to say that, okay, well, they should be treated similarly. But what the tribunal said was that because Canada Post had particular state-related obligations, that they were not in like circumstances. And on that basis, ownership can be a basis of discrimination in international investment treaties. And so state-owned enterprises may not be protected in the same way as foreign investors when they're operating overseas. A couple of other issues are related to non-discrimination, one of which is generally when attempting to establish a breach, the final stage of investment arbitration will attempt to say, is there a rational public policy that a host state has taken here that would potentially justify a breach? Now, competitive neutrality has, in my research, never been discussed as a potential rational public policy in order to justify a potential breach. But the standard of rational public policy established in Pope versus Talbot is generally quite low. And so if, for example, competitive neutrality was a ground on which states would be able to justify breaches, then that would be a basis on which states could discriminate against state-owned foreign investors. Next slide, please. The next standard I want to discuss briefly is fair and equitable treatment. Now, as any of us who have tried to teach the standard of fair and equitable treatment will know, the problem with the standard is that it's very difficult to pin down its normative content. And so there are aspects of fair and equitable treatment that would be relevant to assessing a potential breach of international investment treaties with respect to state-owned enterprises. One is the inconsistent application of a commercial purpose test. For example, in an investment screening mechanism, investors may be analysed for whether they have, quote, a commercial purpose or have kind of commercial intent. The issue is that there are some private investors who invest on basis other than for a commercial purpose. So you have things like ethical investing or green investing. Are these a basis on which those particular obligations may also breach international investment treaties if the commercial purpose test is inconsistently applied? Another way is which lots of these investment screening mechanisms, for example, do not have an appellate mechanism, which could breach areas of due process. Was in that there was a Rawls case in the United States where the absence of an appeals process was considered a potential ground for breach. But other elements is, and this ties a little bit to our previous presentation, was that the investor obligations inherent to fair and equitable treatment often means that investors' conduct will be measured or balanced against host state conduct when assessing possible breaches. For example, there are cases in which transparency has been held to be an inherent aspect of fair and equitable treatment. So if, for example, a state-owned investor is not transparent about how it is directed to act in a particular way, or if it engages in anti-competitive conduct, then in that circumstance, actions taken by host states that would otherwise violate international investment agreements may not, if the investor has acted in particular ways. So again, like with non-discrimination, there is potential here for the regulation of state-owned enterprises to breach the provisions within investment treaties. Next slide, please. So in that circumstance, when there is potential for breach, the question that we have to turn to is, are there exceptions, or what are the exceptions clauses that states could use to attempt to justify those breaches and prevent a breach of the treaty overall? There are three particular issues here. One is that lots of international investment agreements will contain exceptions that reference essential security interests. Now, the scope of essential security interest has been the subject of quite a considerable amount of discussion, but generally it may be regarded as purely relating to kind of defence-related matters or the production of arms. And on that basis, with security exceptions interpreted that narrowly, the basis upon which host states could attempt to justify a breach would be relatively narrow. It may relate only to the sectors related to the defence industry, the production of microchips, things that would clearly relate to particular defence matters. Secondly, there are self-judging, particularly exceptions, security clauses, and also that competitive neutrality is quite often, in fact, is never, in my view, included within the list of permissible objectives. So exceptions clauses may be narrowly drafted. Next slide, please. So what can host states do? In my view, there are three elements that have been taken into account that can be embedded within investment treaties. One is obligations for competitive neutrality and transparency. Two is including dedicated disciplines for state-owned enterprises. And three is introducing obligations for investors, as was talked about in our previous presentation, related to corporate social responsibility. Now, I've given a couple of examples here, but just before I conclude, I want you to have a look on the right-hand side of my screen here, and look at the kind of the soft language used and the imposition of these investment obligations. So it says the contracting party should encourage enterprises operating within its territory. It talks about voluntary incorporation. These kind of soft law or kind of very soft touch obligations related to investor obligations, which is necessary in relation to state-owned enterprises. So I think I'll conclude here. Thank you very much for listening to me, and thank you very much for having me and coming along to this webinar.
Well, thank you very much, Mark, for your interesting discussion. We'll now move on to the next presenter, and thank you also for keeping time. We will now move on to Professor Alexandra Svetlicini, who is an Associate Professor of Law at the University of Macau, where he also serves as Program Coordinator for the Master of International Business Law in English Language. His research focus is on fields of competition law and international economic law, including dispute settlement. He currently serves as co-director of the Southeast Europe chapter of the Academic Society for Competition Law, ASCOLA, and his topic today is the EU-China Comprehensive Agreement on Investment disciplining competition law enforcement in China. Thank you very much, Alexander.
Yes, many thanks for the introduction, and also hello to everyone. My goal today is to give a brief presentation of what is new in the China-EU Comprehensive Agreement on Investment that has been finalized last year in terms of its contribution to the international competition law. So we can start with the first slide. Just a little bit of background on the general situation with the competition law internationally. As probably all of you know, the initial idea to have competition rules embedded into multilateral trading framework under the WTO did not realize. And even though there were some attempts in WTO to continue this work and consider possible agreements related to competition law and policy, this work has been suspended because the countries were unable to find a consensus on this issue. As a result, in absence of the multilateral framework, what we see is just a proliferation of the national competition law regimes and certain soft convergence of the competition rules, which has been facilitated by different international organizations, for example, by the International Competition Network, which brings the competition authorities all over the world for the discussion of the best practices and standards. But competition rules have been continuously embedded in the regional and the bilateral agreements, generally RTAs, free trade agreements, sometimes in the investment treaties as well. So today we are going to discuss how this played out in the treaty between EU and China. Here we would mention that generally EU had a very case-by-case approach to competition chapters in its RTAs. Depending on the counterparty, the EU would insist on a more far-reaching competition law-related obligations or a very limited ones, depending again on the counterparty with whom it's negotiating. China's approach has been consistently to take a very limited obligations in terms of competition law enforcement and never subjected to the dispute settlement under the treaties it concludes. Next chapter, please. Next slide, please. Yeah. During the negotiations, there were a number of competition-related concerns that have been raised by the European stakeholders, namely European companies operating in China or those who are willing to invest in China. Although the competition-related concerns were not the primary concerns, the primary ones were mainly related to the market access. But still, some competition-related concerns were also voiced by the EU stakeholders. They namely related to the lack of transparency and predictability in the competition law enforcement in China, the wide use of non-competition objectives when enforcing competition law by the authorities, and also an alleged favoritism of the state-owned enterprises, which were basically allegedly shielded from the competition law enforcement, thus breaching this principle of competitive neutrality that have been already mentioned in the previous presentation. The next slide, please. So here we see what have the parties achieved in the end. These are the competition-related provisions that we see in the EU-China Comprehensive Agreement on Investment. Basically, they have been covered by the transparency obligation, where each party was obliged to publish the legislation related to the competition law and also the enforcement decisions, at least its non-confidential parts, so that it has to increase the transparency of competition law enforcement. There are also obligations of impartiality on non-discrimination in relation to competition authorities and courts who will review the decisions of the competition authorities. Specific provisions related to the covered entities. In this way, the parties have called the SOEs, the covered entities. The regulatory authorities were required not to discriminate between covered entities and foreign investors when they apply laws, including competition laws. There also were some due process guarantees for the investors, for example, their right to have legal counsel of their choice, their right to recourse to judicial review of the infringement decisions. And also, most notably, these obligations are covered by the dispute settlement mechanism of the treaty. All right, the next slide, please. Here we can see, mention several remarks about the current state of affairs with anti-monopoly law enforcement in China, and this will help us to understand whether the treaty obligations actually provide significant or not added value to the disciplining the competition law enforcement or not. So from 2018, China has opted to have a single competition authority. Before it was 3 different authorities responsible by different parts of the competition law enforcement. From 2018, it is the State Administration for Market Regulation. This authority has continuously improved the procedural rules, publishing procedural rules, guidelines on its enforcement. So we can clearly see certain increase there in transparency, at least as far as the rules and procedures are concerned. The fears or criticisms that for somehow the anti-monopoly law does not apply to SOEs have been rebutted by the certain competition law enforcement against SOEs. There have been cases when the SOEs have been prosecuted for certain anti-competitive practices. Although we should mention that these were mainly local or provincial SOEs, not the SOEs controlled by the central government at this point in time. We also see that the merger review have been streamlined with more clear guidelines and time limits for the procedures. So basically, we can see certain increase in transparency in terms of procedure regulating the procedures. At the same time as the competition laws in other countries as well, the anti-monopoly law contains also non-competition law objectives. One of them frequently considered is industrial policy. And of course, we can see the reflection of it in the enforcement practices and merger review decisions of the authorities. But that is not something that is, we should say, specific only to China, because other competition law regimes also have certain other objectives embedded in their competition law framework, the same in China. The next slide, please. So here I would also mention a few words about the possibility of settling competition law-related disputes that may arise once the treaty would be ratified and enforced. So as I mentioned, all of those obligations, they are covered by the dispute settlement. However, at this point, the parties have only agreed on the state-to-state dispute settlement. The ISDS, or investor state dispute settlement, is still under negotiation, and the parties have committed to come up to some sort of solution within 2 years and bring out some mechanism for ISDS as well. Will it be an ad hoc arbitration or some specialized international arbitration court established for the purpose? It remains to be seen. It remains to be seen because this has to be coordinated with the EU and China general approach to the ISDS. So here we would mention then basically that if both will be in place, then the competition law related disputes could be addressed in the state-to-state dispute settlement and in the ISDS framework. What we have noted before is that the ISDS disputes related to competition law enforcement largely have not been very successful for the foreign investors because the competition law cases are very case specific. And also the national competition authorities normally have a discretion on the initiating cases and investigating them. It has been quite difficult, quite challenging for the foreign investors to find such a clear proof or evidence that they have been overly discriminated, unfairly treated by the competition authorities, for example, intentionally targeted or something like that. So the ISDS have not been that helpful for foreign investors. especially when we are talking about ISDS in relation to China. We also know that European stakeholders have consistently expressed this idea that it would be very inconvenient for them to engage in ISDS in relation to China, because again, they would have to continue their operation in that jurisdiction. So somehow they have always hinted to the preference to have a state-to-state dispute settlement that could help to settle some systemic issues in the competition law enforcement rather than individual cases affecting specific investors. Once again, at this moment, that is only what we have, as the ISDS is still under the negotiation by the parties. So to conclude, some remarks on the next slide. Yes, so generally, if we see there is, we can say that there is a limited added value that these obligations bring in relation to a similar competition chapters that we can see in other RTAs, with the main exception that this time these obligations are subject to dispute settlement, state-to-state dispute settlement, as it is at the moment. Whether they will be effective in protecting EU investors from the alleged arbitrary competition law enforcement in China, that is quite a big question, especially because, again, of the very strong industrial policies, the very strong position of the SOEs on the markets, and the consideration of the non-competition law objectives in the competition law enforcement in China. Once again, it is not something that's specific only to China, having those objectives in mind. So it remains to be seen, but once again, as I mentioned before, perhaps the state-to-state dispute settlement that is currently available could help the parties to address some systemic issues, if any, in the competition law enforcement, and hopefully that would provide some certain form of relief for the European investors operating in China. So that was all from me at this point. Thank you for your attention, and I look forward for discussion.
Thank you very much, Alexander, for your interesting presentation. Our final speaker this afternoon is Dr. Henwai Liu, who is a lecturer at Monash University. His focuses on law and technology and its implications for international economic law and financial regulation. He earned his PhD summa cum laude from the Graduate Institute in Geneva and law degrees from Columbia and Oxford. In addition, he has held visiting posts at Harvard and Columbia Law Schools. His work has appeared in top-rated journals, and his papers have been cited by the Australian Productivity Commission, Singapore Personal Data Protection Commission, Japan's Ministry of Finance, and US Congress. So his topic today is exporting the First Amendment through trade, platform immunity, free speech, and global constitutional moment. Thank you very much, Henwai.
Thanks very much, Deborah, for your introduction. And it's my great pleasure today and to see many of the old friends here. And this is my first time to participate in CBO's conference. And yeah. So I feel like I'm a little bit outlier in today's panel because I think I feel my topic falls within the international investment law and beyond, and I feel within the word beyond. So because I touch upon some of the interaction between free speech and free trade, not necessarily relating to investment law per se. But next slide, please. Let me start by asking you a quick question. If like someone make a comment on Facebook about you, which you don't feel very comfortable or you feel even offended, can you actually demand Twitter or Facebook to remove that comment? And what if Facebook refuse to honor your request? Can you actually sue Facebook for failing to honoring your request? So in most of the civil law jurisdictions, these matters will be handled as a matter of civil code as a matter of civil liabilities. Likely, for common law jurisdictions, it's a matter of tort law claim. And anyway, it seems purely domestic law matter, right? So you may wonder, what's the relevance of this issue from an international economic law perspective? Next slide, please. Interestingly, however, in the most recent free trade agreements that have made this issue as a matter of international law, in the new NAFTA, we now known as the USMCA between US, Canada, and Mexico, there's a new provision titled Interactive Computer Services, which I coined in my paper as Intermediary Immunity Clause. This arrangement provides a very wide immunity to online platforms. So turning back to my example, so if Facebook refused to honor your request, you will not be able to sue Facebook under this new arrangement if that's accepted by many other trading partners in the future. So this new arrangement has been found not only in the USMCA, but also has been found in the US-Japan Digital Trade Agreement, Article 18. And more recently, the USTR is now talking about exporting and doing the same in its trade negotiation with United Kingdom and Kenya. And next slide, please. So, okay, now, here are my research questions and some of my findings. The first question is, where does this intermediary immunity clause come from? In my paper, I argue that these clause is modeled upon Section 230 of Communication Decency Act from the US, a very controversial statute in the US now with its deep root in the First Amendment right of the US Constitution. And the next question is, what are the normative implications for its trading partners, including Canada, Mexico, and Japan? In my paper, I argue that this immunity clause is not as serious as it appears to be in the first place. At least, it's not in the case for Japan and Mexico. To explain, in a side later between US and Japan, Japan actually has minimized or even essentially canceled all of the effects of this immunity clause, saying that both parties recognize that the existing legislation in Japan is not incompatible with what it has committed in the main text of the treaty. But then if we look at the actual framework of Japan, actually Japan has totally different approach. And that's a notice and take down model, which is totally different from the US approach. And similarly, in the case of Mexico, the Mexican government added carve out and annex to the treaty, saying that Mexico government will only comply with its commitment to the extent that it's consistent with Mexican Constitution, in particular, freedom of speech. The only exemption here is Canada. Canada has made no qualifications and accept what has been made in the main text of the treaty. And some of the Canadian law scholars, especially some of the tech law scholars, they welcome this as a good new edition, which will provide a level playing field for Canadians to attract online platforms vis-a-vis their American counterparts. So next slide, please. So our findings above raise a couple of follow-up questions. If the US is really serious about exporting its CDA 230 as a global kind of new template for its trading partners going forward, then why it has allowed the Japanese government or Mexican government to keep so many qualifications that can essentially cancel all the effects? So in my papers, I argue that one possibility might be that because this statute is so controversial that both parties, including Democrats as well, they try to have a kind of overhaul to reform this legislation. And because of that, some of the tech companies, they try to lobby the USTR to export these regimes and make it more difficult to do domestic reform. So this is sort of a tight hand theories. They can lock himself into a regimes that make it a international commitment, and that would be more difficult for domestic stakeholders to push dramatic reforms. In doing so, they can protect their self-interest. So that's one possibility. And as I argue in the paper as well, some of the lawmakers now, they are against exporting and doing the same in the trade agreements with the UK because they are of the view that this is highly controversial, then we don't have a final answer on that domestically. So it's not a good idea to keep exporting these clothes going forward. So the next issue is, will this be a new global norm going forward? And my argument and my preliminary finding is that it's difficult, and I would say it's fairly undesirable. And because, like I mentioned before, there has a big fight between different stakeholders, even within the US. They want to do a dramatic reforms about this CDA 230, which introduced back in 1996. And not just about the US domestic politics, it's very problematic for other trading partners, especially for the EU and China as well, because EU, they have their e-commerce directive, and now they have a new proposed Digital Service Act. And under this new legislation, the EU maintain their notice and take down model, and also they impose the so-called their approach, regulating some of the illegal content and impose more regulatory obligations onto online platforms. And likely, in the case of China, China has a totally different model as well. So it's unlikely that the EU or China, and as I'm continuing my research now in the case of UK or Australia, I don't think the US models will fit into the domestic regulatory framework in many other countries. So to conclude, next slide, please. I think it's these, although the US tried to kind of water down the importance of this clause by calling it interactive computer services, it's not just about business, it's more about free speech. And when we talk about free trade, we are talking about, I think it's not a good place to talk about how we should regulate free speech, because we have too much to trade off. And this is very problematic in the age of misinformation, disinformation, and fake news. And we should respect and we should give different trading partners more discretion to decide what the regimes that should best fit into their local context and serve their local values better. So I will stop here. I'm looking forward to any questions and comments. Thank you very much.
Thank you very much, Henwai, and thank you to all of the speakers. I'm sure you will acknowledge that all of the papers were very, very interesting, although on a range of quite diverse topics, but interesting nonetheless. And now we might have some questions, and I have a few questions here, which I'd like to start with. And the first one is to Carsten and Christina. How can investors' obligations be enforced in the realms of international and/or domestic investment dispute settlement? What approaches do investment treaties foresee in this regard?
Maybe I start, or Christina? I start. Yeah, thank you very much, Deborah. That's a really interesting and also challenging question, because obviously, as I said before, traditionally international investment agreements were confined to stipulating only mutual obligations of the contracting state parties, and subsequently gave the foreign investors the right to initiate arbitration proceedings under this treaty scheme. And the introduction of investors' obligation introduces a new element that potentially also affects the dispute settlement mechanism. Basically, there are a number of different approaches, but I want to confine myself, because I don't want to make it too long, obviously, to two approaches. The first one, which doesn't really challenge the existing structure of dispute settlement under investment agreements, is the possibility of counterclaims. So once a foreign investor has raised a claim for compensation against the host state can initiate a counterclaim, arguing that the foreign investor has not fulfilled its obligations under the treaty. And that's even foreseen in one of the more recent investment agreements, this approach. And of course, more interesting and then more far-reaching approach would be the possibility not only for the host states to independently, autonomously, directly initiate respective proceedings against the foreign investor, but also the possibility of societal actors in the host state, indigenous people, affected individuals, to initiate complaints. That's so far not foreseen in investment agreements. However, we see, and that's my final point, I want to leave it at that for the moment, we see interesting new developments in certain investment agreements, among them the Morocco-Nigeria bid, or the Dutch new model bid of 2019, that foresees that the home state has to provide for the possibility that affected individuals or societal groups affected by the foreign investor in the host country can initiate claims for compensation against the foreign investor in the domestic court of the host state. And that's maybe a new trend. So the requirement to actually extraterritorially apply the respective domestic regime to foreign investors that act abroad, that might be more promising in the future.
Thank you. And Christina, do you have anything to add to that?
No, I don't have anything to add to that. I think this the answer Carsten gave was quite comprehensive in this regard. Thank you.
Okay. Well, look, I've got a question for Mark. Do you think the growth of investment by Chinese state-owned enterprises is continuing to affect investment screening mechanisms, particularly in the US and the EU? And I would raise the issue of the newest proposal in the EU, and whether you've got any comments on that in the context of what you've been discussing, because I know it's been a contentious issue in the EU and has been discussed for several years now. So, do you have any comments on that?
Yeah, thanks a lot for that question. I would say with respect to investment screening mechanisms, both in the EU and particularly in the US, national security has become the new frontier of kind of trade, of kind of investment regulation. So the trade wars that were initiated under the Trump administration got a relatively significant amount of attention. But I think what is beginning to happen now, particularly in countries that are heavily recipient of Chinese investment, is this idea of investment wars, that Europe and America will begin to prevent investors by Chinese state-owned enterprises acquiring particular technology. You see that across Europe, introducing not necessarily at the European Union level, but more at the member state level, investment screening mechanisms introduced that have a broader scope of review than purely issues of national security, but also the expansion of what they considered national security to be. Now, it's a controversial comparison, but one of the comparisons is that, for example, in the aftermath of the terrorist attacks in the early 2000s, the word terrorism was used to cover a whole broad range of regulatory responses to particular threats. And the idea now is that national security may be the frontier with respect to investment to cover a whole broad range of issues. So in the Committee on Foreign Investment in the United States is technically limited to ideas of national security, not to economic security, not to employment, not to considering America's role in the world as a technological leader, but limited to national security. But in practice, the investment screening mechanisms are broadening their scope of review to take into account issues that would go beyond matters related purely to defence. So just to kind of wrap up that answer, the change to investment screening mechanisms with respect to Chinese state-owned enterprises will be particularly in relation to the idea of national security and the expanding definition of national security within those frameworks.
Thank you. Can I just ask a further question, because I'm interested in this area, but how do you see the issue of, how do you see the fact that Chinese state-owned enterprises generally come in far greater numbers within a particular industry than they do for other jurisdictions? You know, I know that in the EU there are a lot of Chinese power companies investing in atomic power stations, or there have been. Most countries have one SOE who does that, or maybe two. China might have 100. Do you see that the implications of the multiplicity of Chinese SOEs in any particular industry change the implications of foreign investment and its treatment by the recipient country?
I think absolutely it does, because it heightens one of the particular concerns I raised in one of my early slides, which is the monopolization of strategic resources and the power that would give to a potential bad acting host state. Not specific, just in the abstract, the idea that any host state, any sort of home state would have control over the entire energy supply of another country. Now, in the UK, for example, there is a nuclear power plant called Hinkley Point, in which they had a significant number of Chinese investors. But when Theresa May became Prime Minister, she put that investment project under review because of the national security implications of having a Chinese investor, particularly a kind of state-affiliated Chinese investor within the UK kind of energy infrastructure. But it was made very clear that at a very high diplomatic level that if this was to fall apart, this particular project, it would have broader implications for other Chinese investors in that country. And I think that's going to be a lasting impact and something to definitely keep an eye on. This idea of not just that of commercial diplomacy, but investment and trade is used to counterbalance some more sensitive issues about how countries respond to more sensitive issues and how they fear that the investment and trade ties with China will impact upon how countries respond to other kind of non-investment and trade elements.
Thanks, Mark. Thanks for answering my question. The next question would be to Alexander. What are your expectations concerning the future of anti-monopoly law enforcement in China in relation to state-owned enterprises? Which venue for resolution of the investment disputes do you find preferable from the perspective of a foreign investor, state to state or ISDS? Thanks.
Right. So on that, I would say that as we have been observing for a longer period of time already, that the trends in the enforcement of competition law very closely follow different industrial policies. So, for example, the recent crackdown on the tech companies, changes that the authorities wanted to implement, and engaged competition law enforcement for that purpose, because these were private companies. This all tells us that we basically would have to watch what would be the developments of the industrial policy, what would be the policy for particular markets, and then from that we can already make any kind of projections about what would be the competition law enforcement there. And the second question about the preferable venue for solving competition-related disputes, probably I already mentioned this in my presentation, that in relation to EU investors and Chinese markets, perhaps the most efficient venue would be this state-to-state dispute settlement, where the parties could address most systemic issues, because that is what actually at stake when we're talking about competition law enforcement, rather than some individual cases that could be maybe handled under the ISDS procedure later. But once again, the experience of foreign investors trying to challenge the decisions of competition authorities in ISDS is not very successful. So I would still say that the emphasis should be on the state-to-state dispute settlement on that particular issue.
Thank you very much, Alexander. And last but not least, Henwai, I suppose I would raise with you, and it may be off the point, but I don't think it is, the issue which arose in Australia in the last couple of weeks of the issue of the platform providers being liable for defamation in relation to things that are posted by others on their platforms. And I'm wondering how you see that panning out. I think was it Google this week said that they would no longer be operating in a particular area, and I haven't read it thoroughly, but you may be able to enlighten us on what's exactly happened and how you see that influencing what you've said already in your session.
Thanks very much, Deborah. I'm now looking at that judgment for my next project, but I haven't looked at that thoroughly either. But as far as I can tell now, I think it's very interesting when I look at like 3 different common law jurisdictions like US, UK, and Australia, and also Canada as well. And their starting point are pretty much similar. They have a common law approach, and they have a very strict liabilities imposed onto online platform like the publisher, and but they have like a different path. Like after the New York Times versus Sullivan case in the US, then we start to see quite divergent paths like taken by the US. And then you see in Australia, we are still affected by the English common law, and to some extent we are more friendly, or we are we don't like the Americans like just prioritize the free speech among others. Like we try to do a little bit different balancing act by protecting more about reputation. So I think the issue here the reason that I am against Americans exporting these intermediary immunity clause is that it's not just about business. It's not just about civil liabilities, allocations among different parties. What's the underlying stakes? It's about different judgment code about how you protect and how you allocate your different social value. Like for some countries, they prefer like free speech, like a marketplace of ideas that's been the paramount importance in the US, but it's not accept, at least not at that level in many other countries, even though in other common law jurisdictions with similar legal tradition, we still have different models. So I would say it's not just a matter of civil liabilities, but it's a matter of constitutional tradition. Yeah. Thank you.
Okay, thank you very much. Look, Mark talked about the very interesting area of competitive neutrality, which has been a great area of interest of mine. And I think Alexander has a question for him. So I'm sure we'd all be interested in hearing that. Alexander.
That's right. I would like to put the question in connection to something that already was asked in the Q&A. So the criticism there that we discussed was that the definition of the security exception is ever expanding. And the criticisms was now that all kinds of things, including the kind of unfair competition, some protectionism and so on, were put under this head of the security exception, FDI screening based on security exception and so on. And then Mark in his presentation mentioned this idea whether competitive neutrality could be some kind of a public policy objective, but also will allow the state to take certain measures against in relation to foreign investors, not calling it security, but competitive neutrality as an objective. And in this sense, we can take the example of the recent EU proposal to screen companies receiving subsidies from foreign states. So when the EU was accused of kind of discriminatory treatment of foreign investors in this regard, the explanation was that actually this is more like a competitive neutrality instrument because the EU companies are subjected to the state aid control. So it's completely equal treatment, the same to foreign investors. So the same state foreign subsidies control. So I just wanted to hear maybe Mark can more elaborate on this idea, on this remark. So how could we really have a competitive neutrality as some public policy exception instead of using this ever expanding security to defend everything?
Okay, I think that's really interesting. Okay, there are two elements I think to this. One is how you're defining competitive neutrality, how broad or narrow you do that. Because if you define it just in relation to subsidy, there are some other elements that would necessarily come into play. For example, regulatory favoritism in a home state may put particular companies in a stronger position to operate overseas. Also, if the government has within their regulation kind of golden shares or captive equity within that company, then they are less exposed to market forces operating overseas. Would this, for example, violate competitive neutrality or not? So I think the first issue you have to discuss is kind of the legal definition of how you are defining your competitive neutrality. Sorry. So in that sense, it's a kind of analogous to the national security problem. Like how broadly or how narrowly you're defining it. As lawyers, we all talk about definitions all the time. We spend our lives doing it, and I'm afraid that's another situation where we would have to. The second one is actually one of fact, because you're going to have to have cooperation between states about the levels of subsidy they are providing to their state-owned enterprises. Now, my understanding is that I'm not an expert in trade law, but the TPP has specific disciplines on state-owned enterprises, one of which provides that states must cooperate in providing a list of the state-owned enterprises to which they give subsidy. And this comes back to a little bit what Deborah asked me earlier about the number, just the volume of state-owned enterprises, and the number of state-owned enterprises China has operating overseas. The database on subsidies provided to some of these state-owned enterprises, because of the number of them, would require a significant cooperation on the part of the Chinese state. Now, we may be able to find out whether that is plausible if China does attempt to join the Trans-Pacific Partnership.
May I interrupt, Mark? Can everyone hear Mark properly, or is his microphone become distorted? Mark, your microphone has become very distorted. Try.
Okay. I'm not sure what I can do about that. Hold on.
I don't know if there's anything you can do. We can't really hear you very more. Perhaps we ought to go to someone else, and then when you come back in.
Okay, is this better?
Oh, that's better? Perfect. Yes, perfect.
Okay, I just disconnected my external microphone. That's fine. Okay, so I'll just very quickly sum up my answer then, if you couldn't hear me. There are two issues. One is of law, the definition of competitive neutrality. The other is of fact, that it would require the cooperation of home states and host states, which is a cooperation that doesn't currently exist.
And you know, it's really interesting when you're looking at you know, the national interest or issues of national importance. When you look at China, China has traditionally taken a very, very broad view of what is in its national interest, and has included things like, you know, as not just the defence area, which a lot of countries have, but others are broadening. But China has always been very broad. You know, they've had food security and telecommunications more broadly speaking than other nations. So maybe everyone else is just catching up. I don't know. But is there anything anyone else would like to add in relation to any of those issues we're just looking at? Or do any of the speakers, we don't have a lot of questions today. You must have provided such a comprehensive information on your topics that we don't have many questions. But is there anything that anyone who has spoken would like to add to their presentation because they, for example, had to cut it out because they didn't have long enough? This is quite unusual. Does anyone want to raise an issue?
So I would have one very quick comment on something that you just mentioned there. So I think
Mark, can I just say, okay, Mark, and then cast it? Thank you. Please go ahead.
Yes, I think one of your colleagues, Vivian Bath, who's written a lot on Chinese investment, the Belt and Road and Chinese investment, has a very good article on that, about the definition of security in Australia and in China. I think it's comparative. And in the Chinese legislation, they don't clearly distinguish between social security, economic security, national security, food security. And so in that context, if we're talking about security, it would probably be broad enough to incorporate competitive neutrality. So I don't want to take up too much time. Please, Karsten.
Thank you very much. You can take up more time if you want to. It's very interesting to listen to your questions and your answers and your comments, Mark. So I would have a brief question to Alexander, because your focus was on the EU-China investment agreement. Just because you are also in China present, what is the perception, as you might see it, in China about the EU-China investment agreement, in particular also as far as it relates to the competition chapter, which obviously was included in this investment treaty in a rather comprehensive way, unusual if compared to other investment agreements, because of the fact that the EU and China do not yet have a free trade agreement to include it in. The same applies to the sustainability chapter, which is also quite unusual to be found in such a comprehensive way in a bilateral investment treaty. That's what it essentially is. It would rather be from the EU perspective, be more commonly introduced into free trade, more comprehensive free trade agreement. What is the perception, as far as you are aware of, if you at all have any impression on that, whether China has maybe, some say China has maybe gone too far, agreed to too much with regard to competition law. In that regard, only I know it's not an easy question for a variety of reasons, but is there any discussion in academic conferences in China or outside of it on that issue? I leave it at that.
Yes, Carsten. So I would mention that, as I said in my presentation, I do not think that at least the competition chapter, the competition obligations, they go that far. I'm not competent to judge other chapters like that of sustainable development. I guess that would be more your expertise. But in terms of competition obligations, as I already shown, the current state of affairs in China largely corresponds to those obligations. So there is certain transparency, there are certain procedural safeguards. So formally, the framework is ready. The framework is ready. When you ask about the general atmosphere about the relation to this treaty, well, in the academic world, of course, they discuss different subjects. Generally, the competition chapter is quite welcome in the academia, because the general belief is that the Chinese markets should be more market oriented. So they should also be disciplined by market forces. So generally, there is a support for these kind of obligations. Overall, it was, I mean, the attitude was quite positive, but then, as you're aware, because of the political disagreements and mutual sanctions, already now it's quite uncertain when the ratification would be again resumed. But in the beginning, when the text was announced, the attitude was generally quite positive here.
Thank you very much. Henwai, you haven't said much. Is there anything in addition that you'd like to add to what you spoke about?
No, perhaps just one final word. I found this very interesting to look at the interactions between online speech, freedom of speech, and the international economic law, because I feel like because the U.S. has different approach as compared to many other common law jurisdiction, and it has enacted a speech act that would deny the foreign judgments recognition and enforcement if it's incompatible with their First Amendment. And then now they have taken another step and exporting their freedom of speech, their right of freedom of speech through international trade agreement. It's more a public international law approach. Yeah, on top of their traditional like a private international or conflict law, like as a venue to influence other common law jurisdictions development of the way they establish the defamation liability. Yeah, that's the issues I'm looking at the moment. Thank you.
Hey, thank you very much. It's a fascinating area. We look forward to seeing more writing from you on that. I have one. Christina has been sitting quietly and is last but not least to be asked if there's anything else she would like to add that she didn't get to say in her presentation, and then I'll go to Mark, who I believe has a question for Henwai. So Christina, is there anything you would like to add to your presentation or any questions arising from what you've heard?
Well, actually, I want to comment on something that was asked in the Q&A that we haven't addressed yet. There's a question regarding what would be the question is, given that foreign investors are already subject to host a state's domestic law and legal and administrative regulatory institutions, one might wonder the necessity of concluding investors' obligation provisions in investment treaties and enforcing them. And so I want to comment on this quite interesting question, actually. Well, I would like to take a quite practical approach on this question. In many arbitration procedures at the moment, maybe not in every country, but it's quite a topic in the EU, especially in the area of the energy sector. There are quite a few discussions on one environmental issues and on the other hand also human rights issues, and whether these can limit in any way the possibilities of investors to ask for compensation for domestic decisions to change the approach to these areas in order to protect these, for example, the environment or human rights. And again and again, there are legitimate or illegitimate claims by investors that national governance might be in a way against their investor protection rights. So it comes again and again that there is this problem that even though investors are bounded by national law, when the approach to certain areas in a big way change, then again there's the question how to deal with it in this international level. So including these provisions of investors' obligations actually clarifies in a much more clearer way the concept of how to regulate and how far a regulation can go, and what are actually the obligations also on the international level, so that it is more clearer in this arbitration framework. This is actually the answer to this question that was asked in the Q&A from my side. Carsten, do you want to add something to that?
No, I think you answered that comprehensively, Christina.
Thank you very much, Christina. So what I'll do now, as our last question, I will hand over to Mark, who has a question for Henwai.
Hi, Henwai. I found your presentation really interesting in a way because I think investment law has been used directly or indirectly to export the economic policy of the global north to the global south. This idea of liberalisation, that states are not permitted to nationalise without compensation, etc., and so on. And what I found interesting about your presentation, and the question I want to ask you, is do you think that international economic law will become an instrument to export other areas of policy? For example, the one you identified there was free speech. Now, I've read some of your other work on artificial intelligence and data protection, and whether you think international economic agreements are going to be kind of the new instrument for countries to try and export their policy on these issues.
Thanks very much, Mark. I think, well, starting out as an international trade lawyers, I feel like in the first couple of years, I really like the idea of international trade law. I have no doubt about harmonization, and I think there's a value out of harmonization. But as we goes by, and for the past couple of years, we see the deeper integration. We have to pay a lot of price for it, and we have to give up. There's a big trade-off, and we are trading off not just about economic activities. We are trading off the way we live. We are trading off sometimes our different social values in some ways. So I think, as I argue in some of my papers, I think we believe there's a good thing for globalization and we need harmonization, but there are multiple pathways toward harmonization. It's not just about top-down approach. We are not just told by Americans or European unions about what we should do in the future, but we should kind of we should pay more respect to different social values when we utilize this hard law top-down approach to harmonize our divergence in the future. I think that's the key message I would like to send in my recent publications, I think. Thank you very much.
Henwai, thank you very much for that last comment. I think it's particularly important. I have thought that a lot in relation to the growth of competition law and the downward pressure on smaller countries to comply with international norms which may be totally unsuitable to them. And I mean, I'm coming from Australia, which is a developed market economy, and the number of times we get told we've done things wrong, even though our markets are completely different to other people's in relation to particular products or services. And that's not even getting to the cultural issues and what we want to be as a nation. So I think that's a really profound note to end this session on. And I would like to thank all of the speakers, the audience, and the administrators. And I'd also like to thank all of the audience for the whole of the 2021 Siebel Global Network Conference and Young Scholars Workshop, and encourage you all to join our annual keynote, which is on, I think, the 17th of November, and will be about the digital environment. And we have speaking at that the head of digital for Herbert Smith Freehills internationally, and our joint centre conference with Henwai University later in the year, and also the Siebel Shanghai Jiao Tong University panel later in the year. And all of these things will be on our events page. So thank you, Carsten and Christina. Thank you, Mark. Thank you, Alexander. And thank you, Henwai. And thank you very much to the Siebel administrators, Fion and Wen, who've worked so hard to get the technology right for all of this. So we look forward to seeing you later in the year at some of our Siebel events, if not at next year's Siebel Global Network Conference. So thank you all very much and farewell.